Good morning once again. I'm sorry for the 12 minutes delay here. This was just to put everyone in the right privileges. Last month, we have seen the essentials of risk assessment. I hope everyone understood what are all the components and what is really required of a risk assessment especially in remittance environment. We usually see this, okay, my customers, and they are low risk, medium risk, and high risk, and I deal with so and so countries, and these are my products, and these are very short and brief. The current expectation is very high. The risk assessment has to be in detail, in different perspectives, and in very futuristic manner. The number of risks has to be very honestly assessed and listed and gauged in terms of the effects and the consequences in the organization. By saying so, I have actually last month distributed a template of the list of, the format of the risk assessment schedule, which has classified the risk components into regulatory risk, business risk, compliance risk, and the perception of from the perspective of owners, directors, compliance department, employees, customers, third parties, and other stakeholders, and also what is current and what is future, what was in the past and what will be in the future. After listing them all, we need to really take them into our compliance program, cross-reference them, and completely attempt to mitigate them by deploying the right technology, policies, and procedures. I also suggest those who are in the compliance responsible positions to keep their compliance program with them, so that they can really compare what we are going to see and what they have, and make a realistic comparison as to what are all the missing components in their practical compliance in their own organizations. So if you want to take a few minutes to go grab a copy of your compliance program and keep it close to you so that you can see what is the expectation and what we have, so that you can find the gap between. In order to formulate a perfect compliance program, you need to really have the following understanding of your business. Usually what we see in a compliance program is a few pages of just a notional, just a statement of who are my customers, how are they really faring in terms of risk, whether they are low, high, medium, or any other category. What are all my products, how they fare in terms of risk, what are the jurisdictions and how they fare in terms of the risk. And from there, we just jump on to other components of CIP, customer identification procedures and due diligence procedures and other mitigation processes, without really connecting the risk components which are definitely to be identified, listed. That's why now the expectation is every reporting entity should have a complete a module of risk assessment. So I again want to reiterate that the risk has to be listed. At least, you know, if you take a normal, every entity has a different different appetite to risk, different exposure to risk, but uh, a normal remittance company should at least, in my opinion, have 50 risks listed in a minimum, at a minimum. So if you say, okay, now we usually go to our touch base with risk assessment, having all these understandings and the mitigation processes in our mind. But I suggest that you remove that you have so much of mitigation process already laid down in your organization. So I would rather look at with a complete neutral approach. Imagine that you don't have anything, you don't understand anything about mitigation processes when you approach your risk identification process, because you need to really say the customer will bring fake identity document. Will he, won't he, is the next process of the identification of probability of that happening in your organization. But when we approach the risk, we have to approach with complete no knowledge available about mitigation, or no mitigation process is available in our organization. Then only you can really arrive at the number of proper risk. And also it is very important for you to wear a hat of different perception to the risk. So you have to look at the risk like a owner, you have to look at the risk like a customer, you have to look at the number of risks as a stakeholder, employee, regulator, in every perspective. So you have to assume so many positions in order to really identify the risks. And then the next stage is to look at how those risks can probably be realistic in our environment. And then the third is the effect of the risk happening in our organization, if at all they happen. And then only you can really bring those components of mitigation to your part B in an effective manner. So the first step in formulating a compliance program is to understand the business environment. What is our goals? What are all the business products and services the business is offering to the customers? And who are the customers? How customers can really cheat us? How they can approach us with a view to conduct wrong things through the risky transactions through our organization? Who are our employees? How did we take them? How did we train them? And how do we monitor them for any possible risk from the employees? And who are our correspondents, associates, and what is the expectation from the regulators? This time I have intentionally added that regulator because in 2006, the regulators approached this industry differently. In 2009, they approached this industry with a different approach, even though the legislative and guidelines remained almost the same for all these 10 or 15 years. But the approach of regulators from all these years have changed. Now, what they are currently at is they have phasing out the guiding or spoon feeding phase, and they are expecting us to be very serious, and they are getting to be hard on the participant organizations. So it is very important for us to understand, if you remain out of touch with regulator and the regulatory expectation, then your compliance program can also be outdated. The same compliance program acceptable to ASTRAC in 2015 is not acceptable to ASTRAC today, because they have started looking into the policies and procedures in so much detail that hardly some of us would be really satisfying with them. That is why this topic we have touched earlier, and we are bringing it back, because we know now that the regulatory expectations have really grown up, and it is standing at the matured cycle of the matured peak of the cycle. So understand the distance between business and the customers. What is there in it? If it is not that if the customers are very close to you, they attend to you every day. There are many of my clients who know their customers very closely because they are very regular and they deal with them face to face. But if you have customers all around Australia and they are occasional customers, some of them, even though they are distant to you, they can be very close to you. The more you know about your customers, the better it would be. Whether the physical, geographical distance may not be a problem in many cases, but the legal requirement of having to onboard a customer face to face and to onboard a customer from a remote location are two different things. So you need to really have an understanding or how much proportion of your customer will be face to face, how much proportion of your customer will be distant based. And there are organizations who rely on third parties to provide some or full of your compliance functionalities. So if the more you rely on third parties to do one or more of your compliance functionality, then you need to really tighten up the compliance reliance and make more ownership of how you rely and how you control that third party as to obtain the quality in your compliance functionality. Almost all of us are reliant on technology today for the provision of compliance program. So when we rely on technology, how much independence we have in the assurance of the technology, how much the formulas, the algorithms are tested and up to the quality you require. And also the information security is something which is very new. The information commissioner is now a regulator for this area. For example, if you are storing your data in a cloud location, or if you are hosting your website through which you provide these services, are hosted through a hoster, and nowadays the hacking is a very, very prominent thing in the information industry. What is your responsibility when informations are hacked or hosting site is hacked? What kind of assurance you need to provide to your customers? What kind of privacy you need to adhere to in maintaining their data These are all things you need to really know and have it in front of you in a synopsis before you even start formulating a compliance program. Chapter 6 of ASTRAC guidelines is a very good foundation for a reporting entity to base on in order to formulate your compliance program, because it stipulates from A to Z of what needs to be in your compliance program and how to do each component of it contains a lot of guidelines, and it's a good idea for you to download chapter 6. It is available in both Word format and PDF format. You can download it and keep it next to you before you commence this job. Adoption of a compliance program by the board is the main thing, because you can create the best or worst compliance program, but if it is not adopted by the board of directors, or in case if it is not a company, by the owners or the partners of the company, otherwise it is not an official document. It needs to be adopted, signed by the board's secretary or one of the directors in representation of the resolution passed for passing this compliance program as an official document even before it is implemented. Otherwise, many people don't have this. They do this, but it is not officiated, or if it is not signed, it is not an official document. Especially when ASTRAC asks you to send a compliance program, make sure that you send one of the signed copies to ASTRAC. Otherwise, it would not be taken as an official document. Same goes with, because it comes in the later portion of this slide, but let me also tell you, because it is related, the appointment of the compliance manager has to be signed and documented as well. So these are the two places where it has to be written in a pen, and it has to be signed and dated. Otherwise, it won't be an official document. So risk assessment, the expectation is grown up. So I again put a lot of emphasis on the risk assessment as a complete module. Please have it as an addendum to compliance program. And it's a good idea to cross-reference each risk by a reference. So I would rather say, if it is a regulatory risk one, and when you identify the regulatory risk, if you have identified 10 of them, let me also give you some example of regulatory risks. Regulatory risk is a failure to register your company is a regulatory risk. Failure to adopt a compliance program is a risk. Failure to appoint a compliance manager is a regulatory risk. Failure to keep your profile information up to date is a risk. If you change your head office, business registered office, the principal place of business, you make any amendment to, or maybe appoint another person as a compliance manager, you need to go back to your ASTRAC domain and update these changes within 21 days from the date of such changes. Failure to report report an SMR, failure to report FT, failure to report TTR. These are all regulatory risks. Whatever abstract can come and capture you, this is from that perspective. So they are regulatory risks. So I will number them as R1, R2, R3. And let's say we have 20 R20 risks, regulatory risks, 20 as identified here. And then when you go and talk about them in the part A or part B of your compliance program, it is actually a good practice to cross-reference them. So I have started out here by saying so in my policy or procedure. I have already sorted that risk out. And in the risk assessment, I also forgot to tell you, it is based on the risks impact and the possibility of happening in your company. You need to also assign a period at which you will come back and revisit the risk. And it's if it is a bigger organization, it's a good idea to also nominate a particular officer to keep track of that particular risk. If it is a smaller organization, it is all going to be someone like a director or a compliance manager. So it is unnecessary to add that, but it's a good idea to have the owner of the risk also. So that shows that you are paying very keen interest in keeping that risk under control all the time. And the second most important thing in part A is arrangements for external and internal audit or internal audit. So the legislative guidelines are very silent about the frequency of internal or external audit, but based on the amount of improvements happening, the regulatory expectation is a minimum of within a maximum of 2 years, an external audit, external review has to happen. In many compliance program I have audited, people have a practice of just copying chapter 6 and just making changes to the name. Instead of XYZ Pty Limited, just change the name and just have it as it is. So cutting and pasting the regulatory guideline into your compliance program is not anymore acceptable. And by doing so, many of these entities, they say this may be audited at a frequency. So it is reproduced as it is in the regulation, but a compliance program, once it is adapted, is expected to have certainty around those provisions required to be here. So in other words, you need to really define. You cannot say maybe or the entity shall make a decision. No, this is actually the compliance program formulation is the time at which you make this decision. This is actually you are creating your own Bible. This cannot be uncertain. So there should not be any uncertainty. You have the freedom to make your time, either it is 1 hour, 1 year or 2 year, but you have to make sure in your compliance program whether it is 1 year or 2 year, and what are all the qualifications. And don't forget to mention about the independence of an external auditor. When you opt to have an internal audit, internal review within your organization, please also make sure the person who was involved in formulating a compliance program, even though he is an internal person, has an independence issue here. Therefore, a compliance manager who was involved in formulating a compliance program for the purpose of internal review also is not eligible to be an auditor, because he already lost his independence. Therefore, there must be another individual who within the organization who may not have involved in the formulation of the compliance program should conduct the review and submit this internal audit report to the organization. But if you have already engaged in an external or internal review, what next? The next must be the remediation. So you need to also receive the report and make sure within 30 days or within a reasonable time stipulated in your compliance program, you need to remediate and document those remediation. And again, it is not just documented, you need to communicate to the relevant authorities within the organization so that the remediated or amended compliance program version 2, 3, or 4 is implemented from a particular date. And this communication may also happen in form of an intermediate training within the organization. So an external audit must be documented or required in that compliance program. An external audit's frequency and the scope must be definite. Okay. And there comes our employee due diligence. In most of our cases, the director is the compliance manager and himself is the employee in one-man organizations. Also, there is no employees, but in wherever there are employees, the employees have to have gone through a due diligence process during appointment, training, and during promotion, and when you put people onto high risk scope of activity within the compliance department, also you need to conduct a due diligence. How and when these due diligence are conducted? When I already told that at the time of appointment or time of promotion or change of activity, and when you appoint someone to a high risk activity within the compliance or framework. And how you do it? You can either engage. Nowadays there are organizations who do this in a professional manner. At a minimum, you need to apply for a police clearance and make sure that the person is capable of doing the work he is assigned for, and then conduct a very deep reference checks and make sure that the organizations he or she tells you that they have worked for has a good standing reference for these people. And these are the minimum you should do when you conduct employee due diligence. And then the training. The training is very important component of the compliance program. Now I'm seeing that ASTRAC is paying a lot of emphasis on this area. The minimum initial training and then the ongoing risk awareness trainings are very, very important. You need to really specify the frequency of these programs in your compliance program. This needs to be part of it, and they are expecting reporting entities to annexure the framework of these risk awareness trainings. This has to be scheduled in advance, but there may be additional trainings happening based on the new changes in the legislation, or when you came to know about a particular risk which may affect your compliance framework, then you may actually bring in a new a training, but you cannot fail in the scheduled training. So when you say that you have a training program, it needs to be detailed actually. So what you are training, how much time you are taking in each component of the training. If it is just a risk awareness training, this can be in detail and typology, examples, production, and all those things. But a training program needs to be documented in detail. So ASTRAC now is checking whether these trainings are sufficient to really bring awareness to your employees. So the most important part of the reporting obligation, most important part of the compliance regulatory framework is that the reporting obligation, which is very, very, very key to the puzzle which ASTRAC is trying to put in front of the intelligence agencies. They now have the capability to compare what you were doing earlier, why your reporting are going down, IFT reporting. It is not just in most cases, complaints program contain, okay, this is what IFT is, a definition expansion, and then so and so we are undertaking to submit this. No, this is not enough. You need to really explain how your transaction log is being taken into, how you capture this information, how you articulate this information, and how you submit this information, and then how you are making sure that nothing is missed out. So you need to also incorporate a procedure so that tomorrow someone by negligence have missed to report a particular transaction or some instances. So there has to be a counter check of how you make sure that reporting obligation is not missed out. And then the record keeping obligation is also very, very important. You need to keep records of all the transactions, all the documents from customer identification to transaction details, any investigations CDD you conducted on any customer. It's not 7 years. It is actually from the last transaction, 7 years from there on. So it is, many people think, okay, I can throw things which are 7 years old. No, it is not correct. You need to keep the full track of all the customers' information you collected and the internal data for 7 years from the date of last transaction he or she had conducted to you. And then the most important thing is the regulatory responses, feedbacks, and remediations, or any communication you have had with regulators or any regulator for that matter need to be up to date. You need to keep your contact details, and you need to have a responsible person all the time ready to receive all those feedbacks and requirement to submit any responses and respond to all these within the time stipulated. So these are all the regulatory requirement, and these need to be articulated and attended to in your compliance program in Part A. Now we need to draw very direct relationship between the risk assessment and the uh, risk mitigation process in part B. Customer identification process is the main component. At least most of us are fully compliant with these things. Customer identification is you need to identify the customers whom they claim to be, and then take them. You need to verify that the customer identification given by the customer is correct, it is comparing to the originals, and the data available in the source is equal. I'm saying this because in environments where the customer identification happens in a remote manner, where you have not verified the customer identification in person, then you need to also verify these data. This is by law. The guidelines clearly says that you need to verify this data through two independent sources. For example, if someone is bringing you remotely, sending you electronic data of Queensland driver's license, you verify the data origins and genuinity of the data from a source which actually brings Queensland main roads data to you. There are agencies which bring this through either private sources or data verification systems available in the market, and then that either that source verifies this for you from two different sources. The white pages is another source which can verify the customer's address in a different manner. So the rule is that you need to do this through two independent sources. That source may be coming from one vendor, but make sure that vendor does this from two different sources. From their specification, you can make sure. And at this time, I also want to tell my New South Wales friends that your state has already started electronic digital license. Many have asked me how to verify the digital driver's license. New South Wales the Driver's License Authority has already released a video or PDF version of the explanatory details of how to verify the digital driver's license. I have also shared these details with in the WhatsApp groups, and I have sent to people those who have required. It is a smartphone-based app. The most important thing you need to verify is the time of refreshing, because the driver's license gets verified every time you press a button or when you seek to be refreshed. So two things you need to really look for. One is the refreshing time at the top corner, and then the animated logo of New South Wales government, because people can actually make picture of it and try to show you. So they will fail in two things. That's why they are saying watch for these two. And for a good reason, they say don't touch their phone. You ask them to show and if you want to see the down, ask for browsing themselves. Ask for pull um, uh, the the scroller down so that you can look at the lower portion of the digital license. So it is, ASTRAC has also endorsed this practice of verifying the digital license. So for those who are doing remote verification, it doesn't matter whether it is digital or not. The data is the important thing, and you have other means of verifying it anyway. So if for those who are physically verifying the driver's license, for you it matters how to take data and verify this. And the second thing, which is part of the KYC, is the verification of sanction screening and PEP screening. Sanction screening is the check for the person you are identifying whether they come under the international sanctions, which are approved by the UN Security Council. And additionally, you need to really look into those sanction lists which you are dealing with. For example, if there is an Australian entity trying to send monies to Sri Lanka, so the Sri Lankan government will have additional sanctions on certain individuals and organizations in addition to the UN Security Council sanctions. So you need to make sure that you hold UN Security Council plus Australian Department of Foreign Affairs and Trade and Sri Lankan, so that you comply with all your jurisdictions in your effort to screen the sanctioned entity. Additionally, so far the PEP screening is not available for free, so you need to definitely go for a paid subscription to have this. So PEPs are not definitely blocked or sanctioned entities. There may be good people in PEP, but you need to pay particular attention when you deal with PEPs and make sure that the risk with PEPs are they are prone to be risky, but they are not necessarily risky. So, and every entity can have their own aptitude of how they handle the PEPs. But when you handle PEPs, you need to really make sure that the PEPs are dealt with with a high risk mode. And then the beneficial ownership. Beneficial ownership, if you are dealing with corporate customers, analysis and verification of ID and sanction screening and PEP screening of all the individuals who are the beneficial owners of that entity is a very important component of ID verification. But when you verify beneficial ownership, every individual to the last layer having ownership of this entity for over 25 or more percentage of the total capital need to be verified in Australia. But if you are dealing with India, the definition is different. They even capture even if the person is not a owner, if he is controlling the entity, he is considered to be a beneficial owner. So this is basically to bring those people who are controlling the entity by keeping their representatives just to hide the ownership. So it is actually 10% in India, the ownership, but the control is the main component there. So if you are not a owner legally, but you take most of the benefits and you are doing the control of the management of the entity, then you still are considered to be beneficial owner. For those dealing with Australia and India, it's a good idea to have the superior of the both in your compliance program, where that is what FATF requires you to have. So once identified all these things, then the risk scoring and allowing. So many of us do quickly, even before a customer starts to do transaction, we ask for bank statement, source of wealth, source of income, and all those things. Actually, if you do this step, you can allow your customers a safe area of dealing. If you score the risk from the components of the information you collect during the initial onboarding, based on the risk scoring, if you profile the customer, okay, because you have a good job, your income is this, and your age is matured, and based on all these, but these need to be really documented. You can't have it in a very vague manner. But you need to really have those scores, and the scores range have to be differently classified, and you can actually allow them to have a little bit of independence even before your CDD or re-KYC procedure take place. Give them a little breathing space. Okay, this is your safe area. If you do conduct your business within that safe area, I allow you to go without any problem. Then you step up and put your other procedures. That will be a most idealistic situation instead of going, and otherwise you will really spoil your business. So there has to be a balance between your compliance and your business. The compliance is actually asking every customer to be suffocated. But by doing these kind of things, really you can provide for a business development so that the business department doesn't bother you so much. But that safe area, again, need to have a clear monitor. I'm not giving a very clean sheet to that area, but the other risk flagging and risk triggering needs to be still there. But I'm just saying that by doing that particular procedure, you can allow customers to really have a safe passage. And then based on your risk assessment, you list your red flags on how you combine your profile risk and the transaction risk, and what you need to really monitor on the ongoing transaction pattern, and deploy the algorithms as a filter point in order to monitor these transactions. Transaction monitoring is not a big thing. If you follow a particular criteria-based red flags, then whatever is triggered by those red flag monitoring, you just conduct a very reasonable research, apply this reasonable person's decision-making rule, and collect the evidences and put your narration of what you have really watched and why you considered it as safe or why you considered it as unsafe. And if it is safe, put back to the system. If it is unsafe, then take it back to the suspicious matter reporting procedure. And now we come to the very important component which links us back to the title of this webinar, which is Dynamic Compliance Program. So what is the word dynamic means? Dynamic means we are quick to make changes and adapt and train, and it is rotational. It is basically a very changing environment. So instead of making a compliance program and letting it sleep, we actually put this to a function where we did risk assessment. We know the possibility of that risk happening within our organization and the impact of that risk in our organization. And we have devised the policies and procedures to match that identified risks. And then we immediately put that to either internal or external review so that it is functionally be suitable and it is legally fit with the regulatory requirement. And whatever the internal or external review identifies as the gap, we, within a reasonable time, we fix it and then bring new and modified policies and procedures, communicate to the relevant verticals of the organization by either training them or appropriately making them aware of the changes and the relevant new requirement in that functionalities. And also, you remember now in the last 3-4 weeks, we have received a lot of typologies from ASTRAC. The one being the child sex offense, the other being the phonics organizations. So when we get these typologies, what we need to do is read these typologies. These are lessons from things which have happened elsewhere. So does this risk applies to our organization? And also we can learn lessons from our own investigations of the transaction monitoring tickets. So all those, in a periodical basis, you bring them back to the risk assessment, include them into the risk assessment, and again bring back to the policies and procedures. There is no such compliance program which is static and applies to any organization all through the year and ages. So it has to be dynamic, and the formula for dynamic compliance program is to revisit the risks by lessons learned and typologies released by the regulatory bodies, and even news. Go to LinkedIn and follow organizations like FATF. There are organizations which keep updating the worldwide risk dynamics. Bring all those lessons and get back to the risk assessment and apply this to all your organizations. You don't need to really make it big, but bring those typologies at a minimum which really applies to your organization. And I think with this, I think all of us, we have a better understanding as to what could be our shortcomings in our own compliance programs. And if you have any doubts or clarifications required, I am available 24/7. Please call me. And now I'll open this forum for any questions. You can go to chat and send me the questions. Sir, do you have any questions? Both Kamran and Narsiv, you are in the line.
Yes. Yes. Ram, can you hear me?
Yes.
Okay. Kamran from Aussie Forex and Finance. Ram, can you touch again the old records? Thing, because you said that probably the 7-year period starts when the customer has done their last transaction, or any transaction which they have done. Let's say if a customer is dealing with a business for 10 years, so we need to, and then he stops at 1st January of this year, then all those 10 years going forward for 7 years. I mean, I just I'm a bit confused about it.
See, the regulatory requirement is that if a customer is still continuing with you, either the customer or the regulatory bodies have the right to ask any information to be reproduced for the next 7 years. It's very hard for you to keep track of those customers. If it is a very huge organization, you can actually archive your information from the last date of transaction. But even after 7 years, what is the assurance that they will not come back and start new transactions with you? If they do, then you still need to hold those old information. So in other words, we need to find ways to keep all the data.
Agree. So it's not the limit as we understood that up to 7 years we need to keep the
Yeah,
record.
you know, the general understanding is that we can throw all the files which are 7 years old. That is not the case. That is exactly what I want to say.
Beautiful, beautiful.
Sir?
Fair enough. Yeah. Very many questions. Nothing from me, Yara.
So, okay. So please, you conclude it.
Yeah, it went off well. Probably most of the people who would have already have a very good program in their organization would also be able to revisit and ensure that whatever was suggested by Ram are in place and keep their program up to date. And it's for the newcomers or rather for people who are really starting off with, it would be better for them to check with Ram on a personal basis or a company to company basis and get to have more details, I believe.
Well, thank you very much, sir. With this, we conclude this month's webinar on Dynamic Compliance Program. Next month, we will be having a webinar on transaction monitoring, and I will let you know the date and time very soon. Thank you very much for all of you to be attending today's webinar. Thank you.